May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the First District Court of Appeal. We have 3 cases on the docket this morning. Between the first and second case, we're going to have coffee in the rotunda for any of the council that would like to join us for that. The first case is Bobby R. Channell versus Baatz and Heartland Automotive Services. Counsel, are you ready?
Yes, Your Honor.
You may proceed.
Good morning, Your Honors, and may it please the Court. My name is Jonathan Martin, and I represent the appellant, Bobby Channell. At this time, I'd like to request 5 minutes for rebuttal. This Court should reverse the order granting Heartland's summary judgment because Baatz was acting within the course and scope of his employment at the time of the accident, because Channell has established all 3 of the Sussman factors, notwithstanding the going and coming rule, for the following 2 reasons. First, the dual-purpose exception applies here to negate the going and coming rule, and second, the special errand exception likewise applies. Now, before diving into the exceptions themselves, it's important to explain exactly how these exceptions are applied here in the third-party context. They are applied as part of the overall 3-prong analysis from Sussman, and they don't replace the Sussman analysis. And so just as the going and coming rule is applied at each factor, the exceptions are applied in tandem with that. And so, as an example, going through the first factor, which requires the conduct to be of the kind that the employee was hired to perform.
So let me, go ahead.
Go ahead, Judge.
Below it was conceded that he wasn't hired to be a driver. So, you know, he's not like a parts supplier driving extra oil between stores or something like that. So how does that fit in then, given that he was not hired to be a driver, he's hired to be a manager? How does that fit in with the first prong?
So the concession that Your Honor is referring to in the brief was part of a larger sentence, and so the declaration was that although he wasn't hired to be a driver per se, such as, for example, a delivery individual, he was hired, and then counsel went on to explain all of the different tasks that he was hired to perform, including the undisputed evidence that demonstrates he was hired to take these business trips to the manager's meetings. And so it wasn't a concession that the third, for example, that the first prong wasn't satisfied in this case. And
would you agree that if he regularly went to the manager's meetings, like he was normally in McClinney, but one day a week he had to go and be backup manager at the Orange Park store, would you agree that then that would be subject to the coming and going rule and he wouldn't be covered here?
Yes.
Or he would not be in the course and scope of employment?
Yes, Your Honor. If that was his usual practice, then it would not, for example, be a special errand in that instance. And there wouldn't be anything special about it to bring him within the exception. And so as applied to the first Sussman factor, which again requires that it be of the conduct that he's hired to perform, a flat application of the going and coming rule could lead to a finding that he was merely going to work. But
well, you've characterized this manager's meeting as a business trip. Was he reimbursed for mileage or paid any special expenses for going to this manager's meeting?
No, he wasn't reimbursed for the mileage, and he was using his personal vehicle. But
and this is a regularly scheduled meeting, correct?
Well, as the trial court found, it's sporadically scheduled, and so it is something that is scheduled periodically, but it's not something that is scheduled ahead of time that Baatz has known about. It kind of pops up, and then he's informed. In this case, it was the weekend prior, and he went on a Tuesday.
Would it make a difference if he had to report to that location once a week?
Yes, Your Honor. Then it would be more periodically, and it would just be part of his usual routine, and so it wouldn't fall under one of these exceptions as being anything exceptional beyond his normal work routine.
So how would you define a normal work routine? I mean, if it's expected that he has to go to these periodic meetings, what makes it routine versus something that's, a special errand or a dual-purpose type of trip?
Well, it certainly depends on the facts of the case, and so I think looking at the factors to consider that are located within the special errand exception itself would help a court in a particular case decide. And so those factors are the relative burden of the journey compared to his usual commute, the irregularity of the timing and the nature of the journey, the suddenness, the time and length, and then any other special circumstance. Special circumstance, of course, here being the fact that he was transporting the documents that were essential to the conducting of the meeting. And of course, this was highly irregular compared to his usual commute, which was going to the McLaney store, because here it was 45 minutes in the opposite direction to another city to attend a manager's meeting, as opposed to his usual burden of merely driving to the McLaney store. And so applying the special errand exception to the first Sussman factor, it could be found that he was on a special mission that he was required to perform for his employer, and thus he was performing conduct that he was hired to perform.
Could you go to the documents? Was he required to bring those documents, asked to bring those documents? What were they doing in the car?
And so he was required to bring those documents, so much so that the trial court made a specific finding that is supported by competent substantial evidence that the primary purpose of the meeting was to review those documents to evaluate Baatz's store. And Baatz explained in his deposition, which was undisputed, that he would have been sent home to retrieve those documents had he failed to bring them. That's how important that documentation was. And so looking at the second Sussman factor, which requires that he be in the time and space authorized or required to perform the work required, in this instance, he was at the time and place on the road at that time to timely transport this essential documentation to the meeting, thus activating the special errand exception, which would negate the going and coming rule in that instance, allowing the second Sussman factor to be satisfied. And of course, the third Sussman factor in this case was conceded to be satisfied below, that is that he was motivated, at least in part, by a purpose to serve Heartland.
How does the 7:30 start time versus a midday start time? You say he started working at McLaney, and then at noon he had a meeting in Orange Park. Would that be more supportive of a finding that he was within the course and scope of his employment if it was his workday had already began somewhere else?
Yes, Your Honor, but in a different light. So, for example, the going and coming rule would not simply be applicable at all if it was midday and he had already been working and he was simply continuing his work. And so the fact that he began the trip before his usual start time requires an application of an exception to the going and coming rule. And as part of the analysis for the special errand exception, actually starting beforehand to perform a special task for your employer could actually lead toward a finding that it is in fact a special errand for the employer, because it required a deviation from the normal and usual pattern of his employment. And going towards the dual purpose exception itself, usually it is applied in situations where there's a sufficiently important concurrent business reason for the travel. And so that usually comes down to, and is relevant to the facts of this case, whether they're carrying the work-related paraphernalia or it's a business trip. And of course, again, as the briefs emphasize, that's not automatic. When someone's carrying work-related paraphernalia, it has to be determined on a case-by-case basis whether it's sufficiently important part of the journey. And of course here, again, the trial court's finding that it was the primary purpose of the meeting to evaluate those documents, to evaluate the store, makes his transportation of that documentation sufficiently important. And in any event, it's at least enough to survive a summary judgment motion and let the issue be decided by a jury.
Well, let me ask you about that. Both sides moved for summary judgment below, and the facts were stipulated. So can you now argue, well, wait, there was a factual issue and summary judgment was not appropriate?
Your Honor, it's our position that we are not arguing that there is a disputed issue of fact. However, in the appellee's brief, they were belittling the importance of carrying the documents, which was in conflict with the undisputed evidence, and so it's an alternative argument. If appellee is going to contest the undisputed facts that should lead to the application of these exceptions, then and only then we would argue that a reversal would be needed and this case would have to be sent to a jury. So no, our primary position is not that the facts are in dispute. And so going towards the other part of the dual purpose exception, which is a finding that he was on a business trip, in that circumstance, this court should find that because he's driving 45 minutes in the opposite
So
direction.
what if you had an employee that had no fixed work site, and every morning that employee was required to call in and see which of the 4 work sites of the company they were supposed to go to that day? Would the employer be vicariously liable if they were in an accident driving to their work site that morning?
No, Your Honor, and that's a perfect example of what happened in Freeman, and that's because that would be that employee's usual day-to-day routine would be to call the employer, receive the call back, and then report to the work site. And because it's their usual routine, that is why it wouldn't fall into these special areas.
So how's that any different where you have a situation where an employee has a usual work site, but occasionally they're required to go to a meeting at a different work site?
So it depends on how occasionally that is and how regular the route is to that area and all the other factors that are relevant to the special errand exception. And so if that occasional work site is the same work site, performing the same work, taking the same route to that work site, then it would be more difficult to lend to a finding that the special errand exception applied there. But if it's like here, where the route has never been taken before, and it's something that he's doing that's unusual compared to his usual routine, which is, of course, going to the Jiffy Lube store as a manager, it lends itself more to a finding that the special errand and dual purpose exception apply, and makes it look more akin to a business trip that's outside the ordinary focus of the employee's work.
But what about regional managers who will typically carry documents in their cars and they're going to go supervise different locations, maybe look at performance reports? Does that mean every regional manager now, the coming and going rule just doesn't apply? Does it eviscerate it for vicarious liability purposes?
Well, again, if that's their usual routine to go to different areas, then in that instance, it would seem to me that if they hadn't gotten to that area yet, then the going and coming rule would apply to them, and there wouldn't be anything special about their conduct because it was their usual routine. But if that's their job to travel, then the going and coming rule wouldn't even apply, and their conduct would fall within the scope of employment just because. And with that, I'll reserve the rest of my time for rebuttal.
May it please the court. Good morning. My name is Bill Stone. I'm with the Sawfield and Shadd law firm in Jacksonville. We represent the defendant in the court below, Heartland Automotive, doing business as Jiffy Lube. It's clear from the court's order below that the court relied on the Sussman case and discussed the 3 Sussman criteria, and you have to have all 3 of those, of course, to be within the course and scope of employment. The order recites the fact that both parties agree with that test. Counsel says here that he agrees with it as well, and yet he wants these workers' compensation doctrines to essentially trump the Sussman analysis. As the court pointed out.
Well, you got to admit there's a little bit of inconsistency if you have the employer agreeing that the employee was within the course and scope of employment for workers' comp purposes, but not for vicarious liability.
Well, that didn't happen in this case. I understand that's in their brief, but the workers' compensation carrier can make whatever decisions it wants to make about whether to accept Mr. Channell for purposes of comp. It has no bearing whatsoever on the liability issues.
Well, Mr. Baatz also admitted, didn't he, that he was within the course and scope of employment?
I think he said that at one point, and then another point he was less certain about that question, but that's not binding on us either.
Does that create an issue for a jury to sort out whether he was or wasn't?
No, I think they have acknowledged that that is not binding on us that when Baatz makes that admission. In fact, that was the Sussman case where they found that there was comp coverage for Sussman, but then it was a different consideration for purposes of these third-party liability cases. As the court pointed out at the hearing below, factor 1 in Sussman is that the conduct is of the kind you're hired to perform. They conceded at the hearing that this was not the conduct he was hired to perform.
Well, he wasn't hired to be a driver, but part of his job duties did require going to off-site meetings then, right? So what do we analyze? Just the very narrow, okay, well, he's not a driver, he's not transporting oil filters between stores, or is it more broadly, his duties occasionally require him to go to a job site, somewhere in the greater Jacksonville area?
If he were driving, delivering parts between stores, that would be a different case, and I understand that. But his workday that day was in a different location. It was a meeting. The chilling effect that a ruling like that, in this case, if you were to find that every time an employer has a meeting with their employees, and let's say they require the employees to bring their laptops to the meeting because their data from their work is on their laptop and they can't assess that employee at the meeting, now you have expanded the liability. I don't know how businesses could operate, because now they would be liable for whatever conduct the employee has, of this traveling to the meeting with their laptops. I mean, that's essentially what this would amount to. This was a meeting that was, I'm going to get to that in a moment, this was not a irregular thing. And Baatz described it in his deposition as a monthly meeting. But the ruling below is clothed with a presumption of correctness, and when they concede that driving is not one of his jobs, that's factor one of Sussman that they don't meet. That's the end of the story. But the second, he's hired, of course, to be a store manager. That is his job. What's the inventory? Control of your employees at the store, training employees, hire and fire employees. He's not hired to drive. The second Sussman criteria was whether...
Well, part of being a manager is going to these meetings, though, right?
Yes, sir. Just
Okay.
like any manager. And he had only been a manager for about 6 months or so, according to his testimony. He said the middle of 2016, he said June. This accident is in January. And he said he'd been to 2 or 3 of these meetings. So they're not that irregular. And he described them as monthly.
Would frequency make a difference? Let's go to the question I asked the appellant's counsel. If it's a regional manager who has to check on different stores within a geographic region, and they're, going with some regularity, but not scheduled to go check on one store in, Crestview, another in Tallahassee, would it apply then?
You asked, I think, if it was a weekly meeting, would it make any difference?
Right.
I think counsel said it wasn't. These were monthly meetings. I don't think it makes any difference. That's not really what he's hired to do. And if part of being a store manager is to go to a meeting, whether it's weekly or monthly, I don't think that changes anything. Now, if he were like a traveling salesman, or like the trade show situation in the Swartz case, the Supreme Court Swartz case, where there's constant trade shows, I think that's a different situation. There's no dispute in the record, and the court below indicated that there was no dispute that his workday had not started, nor was he at the location of his job. Baatz concedes that as well, which is the second factor in the Sussman case, that the conduct occurs within the time and space limitations of employment. Now, I think it's important that they put so much emphasis on the special errand and dual purpose doctrine, and actually argued in their initial brief that this court has said that it should be considered instructive. That's really not what the cases say, and that's not what this court has said. The cases say that these work comp doctrines can be instructive. The order below from the judge indicated the same thing, that they can be instructive, but they're not dispositive. They agree with that. So these decisions on special errand and dual purpose, they're not dispositive, they are not controlling. In fact, in the Freeman case, this court's opinion, where that was mentioned, and they mentioned one of the special errand case of the Edie decision. The Freeman case is the manpower employee who's directed to go to a job site, and the job sites are different every day. And this court in Freeman said that the journey was not a substantial part of the service for the employer, and that's the same thing here. This court noted that he wasn't reimbursed for his car. Same thing here. This court noted that manpower had no control over the driver with respect to his trip or the job site or the route he was to take. That's the same thing here. Jiffy Lube has not 1 ounce of control over how Mr. Baatz decides to get to work, what route he takes, whether he wants to drive a car that's safe or unsafe, whether he wants to drive safe or unsafe. And Baatz said he could take Uber if he wanted to get to work. I think the Pierce case is also an important case from this court on this subject, because Pierce talked about, cited the court's opinion in Freeman, and talks about how workers' compensation doctrine may occasionally be instructive, but it said the governing principles are not always identical with workers' comp doctrine and should not necessarily control such tort actions, citing Sussman. This court also said in the same opinion, the attempt to effectuate a wholesale and unqualified importation of workers' compensation doctrine into this type of civil litigation is rather questionable and potentially misleading. There are a whole host of reasons why these doctrines are not controlling or dispositive, and I will give you 3 of them. One of them is mentioned in Sussman because of the different policy considerations between workers' compensation. And so Sussman says we have a more narrow analysis. Look at the workers' compensation statute, 440.092.2. It actually has the going and coming rules spelled out in the statute. At the end of subsection 2, they reference the special errand and dual purpose exceptions in the statute. Where is that in Chapter 768 in Florida? It's never been adopted. The legislature has never expanded employer
All
liability.
torts, though, aren't in, you don't have to use 768 for a negligence cause of action, right? I mean, that's still, we still have a little common law left, right?
No, you don't, but if you look at 768, there are some examples, there are different contexts where they talk about vicarious liability for employers in 768. If the legislature thought that this should be incorporated for all businesses and change the common law, they could have easily put it in 768. It's not there. And the other thing is, as we mentioned, I think the chilling effect that this type of broad application would have on business, where you can no longer have a meeting with your employees and no longer ask them to bring their laptops to work, to the meeting.
Well, let me give you a hypothetical. I'm a young associate at a law firm, and this is back in the pre-electronic filing days, right? So the runner's out or sick or already on a mission, and the senior partner says, we got to get this filed before 5 o'clock. So I take off down to the courthouse to get the document filed before 5 o'clock, and I'm in a wreck. Is that within the course and scope of employment?
Well, it's within your workday, you know, and that would probably satisfy the time and place requirement that Sussman talks about.
So what if instead of file this by 5, he said it's 6 o'clock at night, and he says, tomorrow morning, this has got to be filed. On your way into work, file this for me.
And it gets closer to the special errand exception, which I acknowledge can occur. It's not applicable here. It gets closer to the special errand exception. The boss, the senior partner is telling him the night before, I want you to deliver this tomorrow morning on your way to work, to the courthouse. It gets closer to that. In this case, if you look carefully at both the special errand exception and the dual purpose doctrine, neither one of them apply. I would submit to you that if this were a pure comp case and this court were considering a ruling in the court below that this was not compensable, you may very well and probably should find that neither of these exceptions even apply. Because in Schwartz, the Supreme Court case, they talk about both doctrines. And they say what's important about the special errand doctrine is two things: irregularity and suddenness. You have neither of those present here. Baatz testified, it's in the record at page 183, that these were monthly meetings. He said he'd been to 2 or 3, and that's in about 6 months. Now, they say that he'd only been to 2 or 3 in over 2 years of employment. What they're not telling the court is he started out as a technician at a Jiffy Lube. So he'd only been a manager for around 6 months. Said he'd been to 2 or 3 of these monthly meetings, nor was it sudden. The notice for the meeting was not sudden, which is your example, Your Honor, of the senior partner saying the night before, drop this off in the morning to the courthouse or wherever. It's not sudden. Baatz testified, and this is in the record at page 185, that he usually gets a week's notice for this manager's meeting. It's clear from his deposition he didn't know exactly when he was told about the meeting. With the same page of the record, 185, he said, the notice here was, quote, maybe the week before, unquote. That's what Baatz said. So it's not irregular, it's not sudden. Now, the dual purpose doctrine also does not apply, and here's why. Schwartz talked about the criteria for dual purpose. And Schwartz said, well, look at Nico Gold. We talked about the criteria in the Nico Gold case. And if you look at the Nico Gold case, there's 2 pieces of criteria that are absent here that they talk about in Nico Gold. One is Baatz is not paid to bring this material into the meeting. And there's 3 important dual purpose cases that discuss this, and they can all be understood and reconciled if you follow this. But the other thing is the materials that Baatz is bringing to the meeting have to be essential not to Baatz, but to Jiffy Lube, because it's Jiffy Lube that you're trying to hang the vicarious liability on. So these materials have to be essential to Jiffy Lube. There's been no suggestion and there's been no evidence that just because Baatz is in a wreck, that somebody had to drive out to his car and get this material and bring it to the meeting. If Baatz is sick that day and can't go to the meeting, there's no testimony that they have to go get his materials for the meeting. They didn't send 10 or 15 or 20 of the other managers. All the managers had to bring their notebooks and data. They didn't send those 10, 15, or 20 managers home that day because Baatz didn't show up at the meeting. That's the difference. That's how you reconcile these dual-purpose cases. And if you look at the three of them, there's three of them together, all Florida Supreme Court cases, the Nico Gold case, the Rowe case, and the Gilbert versus Publix case. That was the difference in those three cases. In the Nico Gold case, the employee is taking the money home and he has to return it the next day to the business or they can't open because they can't provide change to customers. And he was paid for that task. Look at the Rowe case, look at the Gilbert case, neither was paid. In the Rowe case, the employee carried the money home, carried it back. She wasn't paid for that. They didn't need the money to open the business. So they said that was not an essential purpose for the employer. Same thing in the Gilbert versus Publix case. The employee who's assistant manager of the Publix, who's drafting his newsletter at home, she's bringing the newsletter into the store at 4 o'clock in the morning when she's supposed to open. She's not paid to transport the newsletter in, but the court said that Publix didn't need the newsletter for the business to operate, for them to function. That was the difference. So that's how those cases are reconciled. So it has to be essential to Jiffy Lube. Those documents might be important for Baatz, but the meeting doesn't get canceled just because he's not there and doesn't bring those documents. That's why the dual-purpose doctrine does not apply, nor the special errand, because this was not irregular, nor was it sudden. So those doctrines don't apply. They don't control. They're not dispositive. We have 2 of the 3 Sussman criteria that are clearly lacking in this case, and the judge was correct below in entering summary judgment for the defendant. Thank you.
Thank you.
Your Honors, starting with the fact that the workers' compensation cases don't necessarily control here, all, from Pierce and Sussman, all that means is that if this court were to, for example, find a special errand exception or a dual-purpose exception applies, in the workers' compensation case, that just ends the analysis. There's no Sussman analysis. There's no 3-factor test. There's no spatial and temporal discussion. And we're not arguing here that that should apply in this instance. We're arguing that the exception should be instructive and inform this court's analysis while performing the Sussman 3-part test. The Sussman 3-part test needs still be applied. And then moreover, as far as the decision in Nico and Rowe with respect to the dual-purpose exception either being applying and not applying in Rowe, in Nico that was the tour bus ticket salesman who was taking the cash to and from work. And so there was evidence in the record that the business could not properly function without the cash being present and at the business. And similarly here, there's the trial court finding that it was the primary purpose of the meeting to review those materials to evaluate Baatz' store, which is something that Heartland wants to do, not something that Baatz would have a personal reason to have been done. And so it was something for Heartland. And then in Rowe, that's the nursery.
So would it have been a different result if Baatz was required to email those documents the night before and he didn't have to carry them actually physically in his car?
It would certainly be a strong fact that would weaken the plaintiff's case here, because in this instance, looking at the factors that are involved in the dual-purpose analysis, making the journey itself a substantial part of the service for the employer is important. And so if he did not have to transport those materials, it certainly would make plaintiff's case a lot more difficult. But of course, that's not what we have here. The transportation of the documents were thoroughly important to the journey, to the service, to the employer. And
okay,
moreover,
well, let's go back to my young lawyer kind of hypothetical here. Young lawyer's got a deposition at 9 in the morning, and rather than going into the office, goes straight to the court reporter's office. Brings with him the file from the office the night before, can't do the depot without the file. Gets to the court reporter's office, or tries to get to the court reporter's office and gets in a car crash. Is that crash in the course and scope of employment then, even though his normal workday wouldn't have started yet?
So in that instance, it's a lot more difficult to apply the exceptions because his usual work routine is to attend depositions and do those sorts of things. And so the argument there would be that he had already begun work because he had grabbed the information beforehand and this was continuing the process. But it's a different line of argument than applying the exceptions to the going and coming rule. It's more an argument that the going and coming rule doesn't apply because he had already begun work, which is something similar that the plaintiffs had to do in the Pierce v. Lott decision, which is why the special errand exception couldn't be applied in the jury instruction, was because there was an argument to be had that the individual had already begun work, and in that case, the facts were such that the special errand exception could not have been found there. Plaintiff even admitted that the special errand exception could not be found given the facts that were presented. And to make one point perfectly clear, the special errand exception and dual purpose exception do already apply in the third-party context. This is not an expansion of the law. The court in Rebello versus United Consumers was very clear. That was a third-party case, and it stated directly that liability will not be had, vicarious liability, because of the going and coming rule, unless the special errand exception applies in that case. And it was simply that the facts of that case were not strong enough to warrant the result of liability there. And similarly, in the Adams versus Mitchell case, the 5th District specifically considered the dual purpose exception in that third-party liability case. And again, the facts were just not strong enough to result in liability. And here, the facts are strong enough to result in liability. They are more akin to needing to bring the cash in Nico back to the store so that it can operate, just how the primary purpose of the meeting was to review these documents, as opposed to the nursery employee in Roe, where there was no record evidence demonstrating that it was even helpful for the employer to bring that cash back. And of course, the special errand and dual purpose exception, therefore, didn't apply to that case, unlike they do here, which has much stronger facts. And so this is not an expansion of law, and for this reason, this court should reverse the trial court's decision and grant Channell's motion for summary judgment, or at the very least, require this to be submitted to the jury. Thank you, Your Honors.
Thank you, Mr. Martin. We will now take a 10-minute recess to have coffee in the rotunda.
All rise.